Showing on this episode of Law Weekly, we look at some of the issues trailing the Electoral Reform Bill and much more. We have the views of Senior Advocate of Nigeria, Babatunde Ogala. Also showing on this episode of the program, more reactions from lawyers on the electronic transfer of results during elections, plus a recap of the top trending legal stories. Hello and welcome to the program. I'm Shola Shieli. There's been a lot of talk about political considerations influencing the way the lawmakers voted on the issue of the electronic transmission of election results. My guest, Senior Advocate of Nigeria, Babatunde Ogala, is also a former National Legal Advisor of the ruling APC, and these are his views on the Electoral Reform Bill and other issues.
From my understanding of that process, and I want to move away from the politics of it, because I've seen and I've read a lot of politics, a lot of distortions, a lot of name-calling, a lot of lies, conjectures. That is to go back to what exactly did the National Assembly do? Did the National Assembly foreclose electronic transmission results? In my opinion, no. What the Assembly has only done is to make it conditional. Whether I agree with NCC being part of the process and the National Assembly, it's a different cup of tea. It's my own personal wish that we should just leave it to the discretion of INEC, where it is satisfied. That's my wish. But that is also not to say the National Assembly has done anything wrong. You know, some have argued that, oh, the INEC is independent. That is trying to, by putting that provision, you are trying to circumscribe the independence of INEC. What independence? INEC is independent, but it is still this National Assembly that is amending its laws. It is this same National Assembly that has oversight functions over it. It is this same National Assembly that appropriates funds for it. It is this same National Assembly that does that it accounts for its funds to. So there is no way we can say it's totally independent and they are not dependent on each other. And it is still the same National Assembly that we are saying should amend its laws. So for me, it is so much of politics that is at play, even by my own professional colleagues. And that takes me to the issue of having legislative agenda. Were these senators, these members of the House of Representatives, who were they even representing at that point? At their state caucus levels, did we know what they agreed? Even those of us who are now in the public space, now criticizing, were we even aware of when that process was going on? What did we do to engage the lawmakers? What was the position? What was the position of the Lagos State Caucus, the Southwest Caucus, the Southeast Caucus? Where I even read that out of 15, 11 or 12 were absent on the day that bill was being passed. And yet, you are most critical. If you want to criticize, would you criticize your lawmakers? Today, what do I read? Buhari does not want electronic transmission. APC does not want electronic. The worst culprits are those who were not present. Not those who even voted one way or the other. Those ones should be celebrated for taking a position.
Flowing from the issue of the Electoral Reform Act is the fact that the lawmakers have also passed a bill that seeks to establish an Electoral Offences Commission to investigate offenders and electoral offences and prosecute offenders. What are your thoughts about the Electoral Offenders Commission? Because many people would say that this is something that the police can also deal with.
We are setting up a commission for electoral offences, in my opinion, is surplus to requirements. Why do I say that? What makes electoral offences different from any other criminal act? Ballot box snatching, there are enough provisions in our criminal jurisprudence to deal with that. There are enough provisions in the Electoral Act to deal with that. Falsifying figures, there are enough provisions in our criminal laws to deal with that. Collecting bribe, there are enough provisions in our laws to deal with that. Perpetrating violence, there are um, enough provisions in our laws to do. Underage voting, and indeed anything you want to call, anything, and I mean anything, you want to call electoral offenses. So as long as, even if you set up the offenses, if we have not been dealing with it in the past, that commission too will just be another lame duck. It will just be there. Some people will stay down there and say they are they are investigating electoral offenses, and nothing will come out of it. And what are we going to have? Most of the operatives of that commission will also be from the police, the same police, just like we had and still have in the FCC, ICPC, and indeed all those special bodies that were set up for certain categories of offenses. So, in my opinion, it's an attitudinal change that we need. Some of these things cannot be done by legislation. It's attitudinal. It's about orientational change. It's about us accepting the sanctity of the ballot box. It's about us moving away from politics of do or die. It's about us moving away from I must be in office at all costs. It's about us eschewing these deep-seated corrupt tendencies. And when we even blame the political class for all of this, it's in all of us. Electoral offense, does it include vote buying? Does it include giving people money at the elections? Does it include giving people money pre-election? The political class, the office speakers, the office seekers, who are bribing voters, is it not because the voters are willing to be bribed? If you go into a constituency and they reject you and your money, you will now realize that you have to start coming with ideas. Hey, look, I've participated in elections, and I know how it works. Through the religious bodies, you want to go to a church, for instance. I mean, we've read of some clerics who at some point endorsed some public office seeking persons, and are now vehemently against them because they say since he got there, he didn't do anything for their churches. It is the same with the mosques. It is the same with town unions. It is the same with community associations. It is the same with professional bodies. We know the cost of elections in certain professional bodies, including mine, is outrageous. So it's in the totality of us. Look, the politician, if you say the politician bribes voters, the politician rigs elections, it is because we all collectively collaborate.
Talking about the issue of reforms, constitutional reforms is also very topical because there are those who say that we didn't give to ourselves this constitution that we currently operate. It's a military document, and so they advocate a brand new constitution. But there are yet others who say that an amendment will take care of things. Where do you stand on that debate?
Is it the constitution that is the problem or the operators of the constitution? If you bring a brand new document, bring the American Constitution with all the amendments, add it to the French one, add it to Germany, add the unwritten constitution in the United Kingdom, bring the best of all and put together. Who are those going to operate it? Is it not us? The 1999 Constitution as a document, there's nothing wrong with that Constitution. It is the way we operate it. And if you say you want a brand new constitution, and some have said, oh, we want a conference, we want referendum, we didn't make this for us, how do we go about it? That is what nobody has been able to say. They will tell you it should be ethnic nationalities will send representatives. How would their representatives emerge? If you say, okay, you want awarded representatives, how would you emerge? And above all, which law will even birth all these proposals? Be it a sovereign conference, be it a referendum, be it a brand new constitution. To get a brand new constitution is not too difficult. A brand new constitution under which system of government? Some will say, oh, we should go back to the region. Is it that the brand new constitution you want of 6 regions? Of 3 regions? Of 12 states? Of 36 states? Some want more states. Some have said council local government. Some have said state police. Whatever it is you want, a process must give birth to it. And what is that process? As of today, what we have as a ground norm, which we all obey, because you obey it as much as you vilify it and criticize it, you still obey it. So for as long as this is what we have, we used to use what we have to get what we want. And to get what we want, it has to be a consensus of opinion. Not by shouting, oh, we will secede if you don't do this. You don't do it by threats. And there can be a meeting of minds.
Now, I hear you say that what's needed is an attitudinal change, and everyone needs to come together and work together to ensure the kind of reforms that we want. And that brings me to the issue of Sunday Igboho. And there's been a lot of talk about that, even from some of your colleagues. There are those who say that he can't be extradited. But what are your thoughts on that? Let's start with that issue. Can he be extradited?
Anybody can be extradited from anywhere. It's a process. There is a process for it. If you have an extradition treaty with Benin Republic, it must have stated out the process to follow. If you remember, Iburi was extradited from UAE to UK to stand trial. If you remember the Assange of WikiLeaks, yes, he escaped into the Ecuadorian embassy. He was there for about 2 years because he was in a sovereign country. And the British police was waiting for him outside. So anybody can be extradited from anywhere. But there is a process. But on the Igboho issue, and the call for war and what have you, they are still, whether we like it or not. I see no reason, I see no problem with you agitating and arguing, expressing opinions on why we should create new states or why we should create new countries. I have no problem with that. But when it goes to incitement and the threats of violence, then the security is being threatened, whether we like it or not. Through your comments, and you don't even wait. When a man says, and somebody says, I'm going to shoot you, and he says, I'm going to come back to your house at night, you say, oh, I have to wait until he comes back. No, you must make a report. That's what is called a threat. That is why even our criminal laws recognize what you call threats. But however, without going into the merits or otherwise of the Igboho matter, today is in Benin Republic, as reported in the news, where he was said to have sneaked into. Are we thinking about the laws of Benin Republic that may have been breached? There are laws regulating movement of people across sovereign and geographical borders. Was there compliance with that law in his movement from Nigeria to Benin Republic, or you expect Benin to shut its eyes to that, to the breach of his own laws? Let's leave Nigerian laws. I'm not talking about Nigerian laws. Because when they say that he's being held in Benin Republic, we are not thinking that Benin Republic might even have its own issues. If it is true that if the reports that he was caught trying to escape to Germany with a purported travel document of a Beninois citizen, is there a breach of Beninois laws? So I think we need to also think in that direction before we start talking about extradition. If you breach the laws of that country, you are answerable to that country. So could that even be the reason that is being held by the Beninois authorities?
Finally, you recently celebrated your 60th birthday. Congratulations on that.
Thank you very much.
Can you share with us what is the most compelling thing that life has taught you at 60?
What has life taught me at 60? Yes, patience. Patience. And life has also taught me tough one, because I can go on and another debate on this. But honestly, I think one key thing is to take people as they come. I don't judge people. I don't judge people. I take everybody as they come. I take you for who you are and not what others expect you to be. That is a big lesson I've learned, because I've seen disappointments. Again, I'm somebody who, again, one other key thing is that you cannot disappoint me, because I've learned not to expect. I don't even expect anything. Talk less of so much. I'm open to disappointments. I'm open to betrayals. So that's why I said I just take people as they come. I take you on your face value, and we take it from there.
Now, away from that interview, some senior lawyers have also been reacting to the way the lawmakers handle the issue of electronic transmission of results and the propriety of having same. We have the views of two of them up next.
The Electoral Act amendment controversy is actually something that is very, very much unnecessary. We were on this part in 2019 during the presidential election petition, and we told the entire nation that INEC transmitted the result of the 2019 election because the Constitution, as amended under Section 160 and the Electoral Act, Section 50, allows INEC to conduct election in any manner that they choose to. Section 160 of the amended Constitution actually empowers INEC to conduct election by making rules and regulation as they deem fit. And Section 50 of the present Electoral 2015 deleted the prohibition for electronic voting, thereby allowing INEC to conduct election in any way they deem fit. For the 2019 election, INEC conducted election not electronically, but they transmitted the result electronically. You go to the guidelines and the election manuals. We had corpus who came and told the court that they transmitted results using ZPAD. Just this very ZPAD that INEC denied. They denied not having server. They denied all of this, and it became like a comedy. So I'm happy that we are at this point now that the National Assembly is debating the issue of electronic transmission to be or not to be. The only reason why we will need that specifically spelled out in the law is to avoid a situation where INEC will come and deny that they transmitted. If not for that, they have all the powers to do that. But we don't want them denying that they did it. That is why it is important to have it in black and white in the letters of our laws. So I will first of all say that the National Assembly, both the House and the Senate, have actually exhibited a total lack of understanding of our Constitution. You do not subject INEC's independence to any other government institution. When Section 160 of the amended Constitution even made the president incapable of interfering with INEC, how dare you now make an institution that is under the president have a controlling effect on INEC's operation? If NCC is to determine whether we can conduct electronic transmission or not, invariably that makes NCC a supervisory body of INEC. So it is something that will not stand in the face of the constitutional provisions. So even if they pass such laws, even if they finally send it to the president for assent, a court, properly so called, I can assure you that if we have Courageous judges, courageous judges. The proviso that the Senate and the House of Reps are adding to the amendment they just made will be deleted.
The National Assembly is laboring in vain. It's not within their purview. The Constitution gives INEC the power to conduct election, and that means determining the processes of conducting that election. So I do believe that that matter, whatever they come up with, is going to be challenged in court, and the court is going to rule on it. I, for one, do not see any reasonableness in you using electronic means to accredit voters. And the same electronic means, the smart card, has the facility or the capability to transmit results, and you say it should not be done. So that's unreasonable. And I think that the courts will rule that it's unreasonable, and that is a deprivation of the voters from having the right to know the results of their votes. If I cast my votes and you use the electronic means to verify me, to accredit me, then I'm also entitled by that same means to know the results of the election. So I think that it's going to be a matter for the courts at the end of the day. Nobody can really stop Nigeria from moving forward to more credible elections. Nobody can do that.
And just before we go, let's bring you a recap of some of the legal stories that hugged the headlines.
We begin with the report that a federal high court sitting in Lagos has sentenced 10 pirates to 12 years imprisonment each for hijacking a Chinese fishing vessel, FV Hai Lu Feng 2, in May 2020. Justice Ayakunle Faji has ordered each pirate to pay a fine of 1 million naira each. Delivering his judgment on Friday, Justice Faji said the federal government proved beyond reasonable doubt that the pirates did hijack the vessel, which belonged to Haina Fishing Company. The judge also held that the offense committed by the defendants affects the well-being of Nigerians and its image in the diaspora. The monetary sums in naira, dollars, and various currencies recovered from the defendants by the Nigerian Navy were also forfeited to the federal government of Nigeria. In Ado, the Ekiti state capital, the Federal High Court sitting there has fixed October 6 for judgment in the suit filed by the State Attorney General Olawale Fakwanda against the Inspector General of Police following the dismissal of a pregnant policewoman. The policewoman, Omolola Olajide, was dismissed from the police earlier in the year for getting pregnant as a single and unmarried officer. Counsel to the defendants, Femi Falade, has however asked the court to strike out the suits, citing lack of locus standi, incompetence of defendants to interpret the constitutionality of a law not enacted by them, and multiplicity of actions as a result of an earlier legal action filed at the National Industrial Court, Akure, by the dismissed police officer. But the State Attorney General countered that defending the right of the common citizen is a key function of an Attorney General. The Attorney General is seeking an order of the court to nullify Section 127 of the Police Act and Regulations, which provides for the discharge from the police force female officers who become pregnant while not formally married. In Zamfara State, the Federal High Court has restrained the State House of Assembly from impeaching the Deputy Governor of the state, Madi Gusau. Justice Obiora Egwatu gave the order while delivering a ruling on an ex parte motion brought by the People's Democratic Party, PDP. Justice Egwatu also stopped the House from impeaching other members who are still in the PDP. Governor Bello Matawalle recently defected to the All Progressives Congress, APC, from the PDP, while his deputy did not. The lawmakers in the state had threatened to impeach the deputy governor over activities they consider a threat to the security of the state, which they claim he was part of. And we round off with the report that the Federal High Court has fixed October 4th for the former governor of Adamawa State, Murtala Nyako, to enter his defense in the alleged 29 billion naira money laundering charge brought against him by the EFCC. Justice Okonaban gave the order while ruling on the no-case submission filed by the former governor, his son Abdulaziz, and other defendants in the matter. The judge held that he had gone through the evidence given by the prosecution witness and was of the view that they had established sufficient facts which needed to be disproved by the defendants. The court therefore held that the no-case submission filed by the former governor lacked merit and accordingly dismissed it. He subsequently adjourned the case to October 4th for the defendants to open their defense.
And that's our program this week. Don't forget that you can find these and past episodes of the program on our YouTube page. I'm Shola Shele. Thank you for watching and see you next week.